Welcome to another episode of Talking College Football with JJ Kitchen. Of course, I'm your host, JJ Kitchen. Guys, today we have a special treat. We've seen so many news articles, so many, tweets from different, whether it's the media or the Big 12 or FSU, so much information out there. Some people don't know what's right and wrong. Well, today we're bringing on an attorney, someone who I truly respect a lot because of the confidence, but more importantly, the success in his career, but more importantly, his knowledge of the situation that's currently going on in college athletics, but more importantly, the ACC in general. But before we get into it, guys, the show is sponsored by Colonial Beer, located at 4986 Library Road in Bethel Park, PA, 15102. Guys, again, as always, run by two great Pitt men, small business. Go support them. They have such a great selection there between light beers, like your heavier lagers, so many different options. But more importantly, the Fake Slide Pilsner, which helps pay the players at the University of Pittsburgh and also supports the NIL Collective, Alliance 412, which is a preferred collective of the University of Pittsburgh. Again, guys, go see my friends over Colonial Beer. Great people, but more importantly, small business in Pittsburgh. We always help out our small businesses, especially if they're run by Pittmen. So, guys, again, today we have a special guest, and he's here today, and he's David McKenzie. David, how are you, sir?
I'm doing well, JJ. Hope things are well up in Pennsylvania, Pittsburgh area.
Oh, it's good. I tell you what, it's actually been nice and warm recently. It's been kind of nice.
Yeah,
Usually,
no kidding.
we've had usually up here in Pittsburgh, it's usually cloudy, not too much sun. We've had a lot of sun recently, which has been incredible. And again, I'm extremely happy to have you on because one, the work that you do on a day-to-day basis, the tweets that you put out, has gained so much notoriety, but respect because the amount of detailed information that you put out on a constant basis. And just for me personally, just the amount of fans that I've heard from, whether it's Pitt, NC State, North Carolina, Miami, just so many people asking you to get on the show. I'm just beyond appreciative. I know your busy schedule and everything you're going through on a day-to-day basis. Just can't thank you enough for joining the show. So before we get into it here, David, tell people where they can find you at on Twitter before we get started. Because I always like to have the guests say where they're from, because more importantly, they can follow along, especially what's going on with the ACC.
Yeah, I mean, it's pretty easy to remember. I'm David McKenzie, so it's McKenzie Law. At McKenzie Law is my handle on Twitter. Probably need to do like an Instagram thing too. That seems like what all the cool kids are doing. So, and maybe some other social media, but it's at McKenzie Law. And happy for people to follow me, send me a note or whatever they may wish.
And before we get into the questions about Florida State, Clemson, the ACC, tell the fans right now, just in a summary, your career and what really got you interested in this case between Florida State and Clemson in the ACC.
I have been, in law in one way or another, either on the academic side or the practicing side, I guess for about 23 years. And the bulk of my career has been in intellectual property. That's what, many people do know it, but to break it down is patents, trademarks, copyrights, trade secrets. And I've never really done, or have done, but not extensively, the what's called the prosecution end of things, where you secure the protection. I'm always been the guy you call when somebody's stealing somebody else's intellectual property. And so, I litigate those things. So the bulk of my career has been in that. I've also done a number of constitutional cases and constitutional. My sweet spot is where there's an intersection between the Constitution and intellectual property. And on those questions, I tend to have litigated extensively in those areas, all the way to the United States Supreme Court, as recently as 2020. And so I've done that at all levels of appeals, both state and federal. A number of cases at the Fourth Circuit, as I said, Supreme Court. But so I got in your other question about how I got interested in this case. Well, let me just tell you first a little bit about my ACC background. So this is the historic league more so, but I have two family members that went to Florida State. I have two family members that went to Wake Forest. I myself am a Duke graduate. My grandfather went to North Carolina State. My daughter, my oldest daughter, is currently a sophomore at the University of North Carolina. Um, my I have an aunt that went to the University of Louisville. My parents got their PhDs at Virginia Tech, and then I was raised in Clemson, South Carolina, back in the 80s and 90s, back when Clemson was a cow country. And so, and plus, obviously, my brother and sister and a bunch of family members went to Clemson. So I kind of have ACC bona fides coming out of my ears. I just got to figure out a way to get some family member to go to Pitt and get a degree to a great engineering school or do something, and just to round it out. So I've always been sort of a big ACC follower just by the nature, of growing up in ACC country. That doesn't mean I'm pro ACC or anything like that. I feel like I'm trying to call balls and strikes. But when this dispute developed, and actually, really developed back in 2013, when that was the first sort of round of conference realignment, and I was super interested back then. And then again in 2016, I was super interested in it all back then, and I find it fascinating. And so, over the last year, I've had some health issues I've had to attend to, and I just don't have a full docket of practicing law. So when this dispute came about, I felt like I had some things to say about it, because it's intellectual property. That's at the core of this. So I dusted off my old Twitter account that I think I opened in 2009, and at the time I probably had tweeted like 2 tweets, and just sort of started offering my public musings about the case. And so that's my background. My bias, or I don't think biases, but ACC bona fides and how I got involved in this case.
And, one, it's incredible, just the credentials of just what you've been through in terms of just law, but more importantly, just having family members all throughout the sector. So in reality, all of it may be the ACC, but at the same time, though, it's just in different portions of the country, different ideas, things that you've seen cross back and forth, has certainly qualified you. I think just in general, just the natural education, but more importantly, your experience overall. And it's always good to have an ACC guy on in general. That's someone that's been up and down the coast with all the ACC teams as well. And again, obviously with everything going on with your health and stuff like that, obviously, for us here, talking college football with JJ Kitchen, but Pitt fans in general, again, we're just beyond happy that you're getting better. That's the biggest thing. We will always send our positive vibes to you and prayers and everything like that. So that's why we're really happy to have you on. And I know it's not been easy. So I just want to tell people it's just really, really a privilege to have you on here because your time is valuable. You're a guy that's busy all the time. So we're beyond happy to have you on here.
Thanks, JJ. I'm glad to be here.
So if really the first things first, one of the things that really popped up yesterday from what we saw was a decision in Columbia, South Carolina. We saw a bunch of stuff come out where, really you saw, okay, the trial can continue to go on. The suit can go on in South Carolina and Clemson, right, but also the same thing in North Carolina for the ACC, but also too in Tallahassee. Give us just an update just from just what happened yesterday to where we are now. Because it seems like there's so much going on. It's almost like there's three lawsuits going on at once in 3 different areas. Talk a little bit about that and what's really going on right now.
Well, what's going on right now is sort of a circus act. I mean, it's unmitigated chaos. I mean, you have what really is total of 5 proceedings involving similar, if not the exact same questions of fact and same principles of law. I'll start with Florida. In Florida, you have the Florida State University versus the ACC. That's straight up on the grant of rights and getting out of the ACC. You also have the Florida Attorney General's writ of mandamus action that is being pursued against the ACC and ESPN. I've been incredibly critical about that. I mean, I think that's we can come back to that. And then the third one you have, excuse me, the third one you would have is pending in Pickens County, South Carolina. And that's Clemson University versus the ACC. And then you have 2 that the ACC has brought against Clemson and Florida State. that was originally filed at the business court, which is a unique court. I think only like 5 states have a business court. It was originally filed in the business court and has since, because of some adverse rulings against Clemson and Florida State, have been appealed to the North Carolina Supreme Court. And that's a little bit of a interesting type of appellate path, because if you start off in the business court, your appeals go directly to the North Carolina Supreme Court, and you don't have to stop at the Court of Appeals in Raleigh. So
Yeah.
the status of at least the ones that are pending in North Carolina, the briefing is done on the petition level. So Florida State filed the petition. I think it was in late May. The ACC responded to the petition in I think it was mid June, and we're just sort of waiting on what the North Carolina Supreme Court is going to do: grant the petition, order more briefing, those kind of things. And I think it will. So that's on the appellate level. In South Carolina, you had yesterday Judge Gravely in Pickens County, which is where Clemson is situated, which is the county I grew up in. Judge Gravely denied the ACC's motion to dismiss. It's not completely clear to me the scope of his order from yesterday. I know that he did dismiss the challenge Clemson brought on sovereign immunity grounds, but he otherwise allowed the case to proceed. But I think we just got to wait till the actual order comes out to see what exactly is going on in South Carolina. Now, in Florida,
It's a lot.
Florida,
It's a lot.
yeah, I we'll just start with what's pending with the Florida State case. And it's no secret I really feel like I've tried to hold my fire on the Leon County case, but you have had what's been relatively rudimentary motions practice that you would expect in high stakes litigation, which was a motion to dismiss based on personal jurisdiction grounds, and then also a motion to stay. Pretty simple motions, not all that complex. Most judges would have handled it on what's called the papers, and what I mean by that is without a hearing.
Yeah.
I think that Judge Cooper in Tallahassee, in fact, I know Judge Cooper in Tallahassee held 3 days of hearings, a total of 19 hours, and was about to hold a 4th day. And it was so funny because the ACC attorneys were like, Judge Cooper, my man, we don't need that 4th day. Gee, we know you're going to rule against us. Just go on. And we still don't have a full order from the proceedings on that. So that's proceeding very slowly. And so that's sort of the procedural postures of all the cases. There is going to be a hearing. The next big thing will be a hearing in the writ of mandamus case. That is going to happen on July 22nd, I believe, and that will be the AG versus ESPN and the ACC. I've been highly critical of that proceeding. I think it's an abuse of police powers. A writ of mandamus action is really reserved for a governmental official who is being derelict, not fulfilling their duties. The ACC and ESPN are not governmental entities, and they're not performing in an agency capacity, any kind of governmental function. So I think that will be summarily dismissed, but that's currently sort of the status of what's going on in 3 jurisdictions in 5 cases.
Yeah, and I think you had a great point. And one of the things that stands out, it truly is a circus. It's going around in a circle. And when you look at the timetable of this stuff, recently what came out is, I believe it was Judge Bledsoe talked about how in 2025 he's going to retire. In your opinion, and I want to save this for later, but I think it just really brings it around right now, is do you think that we get any type of resolution, anything before he retires? And if we don't get a resolution, what does that look like? Does the next judge take over? Do they read everything from top to bottom in terms of information? So really, I guess my first question is, do we get a resolution before 2025? And number 2, if it doesn't get resolved, what is the next phase for the next judge that comes in to take over the case?
Those are all great questions. Yeah, I saw that Judge Bledsoe was going to retire in January, and that kind of surprised me. Yes, another judge would take over the case, presuming that it is back before the trial court from the North Carolina Supreme Court. I don't think, and you mentioned about are they going to read all the stuff and get up to speed on the case? The answer is yes, but I don't think you're talking about a voluminous record here. I mean, Florida State in North Carolina hasn't even filed an answer.
Yeah.
We don't have any discovery. That we don't have any transcripts to read. We have just no deposition transcripts to read. We do have transcripts from some of the court hearings, but it's not going to be like a huge burden to get up to speed on these cases. And quite frankly, the issues are not that complicated. I mean, this is a copyright assignment. This is a contract dispute where the interpretation of the contract's at issue. Um, I think you would have to have some discovery or hearing time about the fact that, oh, by the way, Clemson and Florida State received hundreds of millions of dollars under these deals,
Yep.
which, brings in all sorts of equitable defenses. And but I think that the reality is, JJ, that this is probably going to move faster in North Carolina than I think a lot of people think. And the reason why it's going to move is that the North Carolina Supreme Court has shown a propensity. It's not I wouldn't say that they do it axiomatically, but they've shown a propensity, and I think every jurisdiction is this way, to move quickly when there are deep North Carolina, deep South Carolina, deep Pennsylvania interest at stake. And what I mean by that, deep economic interest.
Hmm.
And you are, or it's like a deep, like within a state deep of heightened importance. The United States Supreme Court, will take cases where they're of deep national importance, for example. And so in this instance, you don't have to stop at the Court of Appeals. You're already at the North Carolina Supreme Court. And you're talking about a dispute involving an ACC, a North Carolina entity being the ACC. And North Carolina has dumped millions of dollars into the ACC
Yes.
from a tax perspective. And then you look at it from a more basic perspective. We have 4 institutions that are being implicated in the dispute. Duke, for example, is North Carolina's largest private employer. Wake Forest can't be that far behind. I mean, I know that when I say Duke, it's probably including the medical center as well. But
Yeah.
you know, it is a situation where it is of pretty significant importance, and so I do think that they may act quickly. I can't promise you that, but the briefing, at least the initial round of briefing, is in, and so it is possible that you could see the court take it up on its docket and have oral arguments in the next 3 months. And could it get back to Bledsoe on a summary judgment motion? It's possible. I also would note that just because he's announced his retirement doesn't mean that he can't maintain jurisdiction on this case. I mean, there's a
Yes.
lot of judges who kind of quote unquote retire, but they really don't. They come back for various purposes, and I think that that's entirely possible on this case. Now, whoever's going to be going to replace Judge Bledsoe in Charlotte, I mean, I doubt that a brand new judge who doesn't have any experience would come in on this. I think it would probably transfer to Judge McGuire or one of the other business court judges with a little bit more experience, given the parties and how much money, quite frankly, is at stake.
Yeah. And I think just overall, I was talking to people about that recently on Twitter where, they're not going to bring someone just brand new, has no idea. But I said, even to the point of some of the Florida
Right.
State and the Big 12 fans, I even said, for where we are right now, it's so early on. This stuff is moving so slow. It's not like it would take a lot to catch up. So it was great to hear you say that. But also, too, it's crazy. Just a lot of stuff was breaking the last couple days with the Big 12 really pursuing and a third party saying that there was conversations. Obviously, the one thing that really stood out was that, the Big 12 is trying to get Florida State and Clemson to go to the Big 12. The Clemson and Florida State, their demands are $30 million each, $30 million more each than the next Big 12 team. The biggest thing when I look at this is, the question will go to you is, with how slow this is going, you know, some people have said, well, we're going to have a decision on this in July or August of this year. In my mind, that blows my mind for where we're at currently. Is there any way we get a decision on this in this month, July, or next, in the next month, August, to figure out if the school is going to go to a different conference? But more importantly, I think that the overall Big 12 phenomenon is really just smoke and mirrors at this point. Just wanted to get your thoughts on that.
Yeah, I've heard the rumors about the Big 12, and I think it's nonsense. I mean, the Big 12 would have massive tortious interference claims on its hands if it were to offer Clemson and Florida State a landing position with $30 million more. Massive. And it wouldn't be just from the ACC. I mean, it could be from individual entities like ESPN or Wake Forest or BC or the ACC. So, the idea that they would now, I do think that whoever the commissioner that's causing this ruckus is free to speak his mind and give opinions and all that, and that's not going to be actionable. But if there is if they are actively courting and providing terms and to do something to create an inducement of breach, then that is actionable. So I just think that that's all wild speculation that I'm not really buying that much. And I would also note that one of the things that makes, and this is sort of outside my expertise as a litigator, intellectual property litigator, it's that one of the things that makes any league work, from the NFL to the NBA to the SEC, is an egalitarian media rights model where everybody sort of shares the same amount of money and the like. I mean, in the NFL, that's been sort of their secret sauce, is that everybody gets the same amount of media revenues. Now, each team gets their own like parking and concessions and crap like that. Mm-hmm. But it's not. So I'm not fully buying that at that point, and I think it's just really unlikely that you have an actual offer. I mean, Clemson and Florida State have got to figure out a way out of the ACC, and then they can go to a league. And if the offer comes in, fine, I buy it. But otherwise, I think that is courting a lawsuit.
And I couldn't agree more. And that's why, when I looked at it from a perspective of, especially too, just talking to multiple people, right, to me, it's all smoke and mirrors. The first thing that needs to happen, hands down, no questions asked, is like what you said. They need to get out of the ACC first, if it's even possible. And the way that this is going, to a lot of Florida State and Big 12 fans, at the collapse of the ACC, all this stuff, which I think is just nonsense because of the massive nature of what the ACC network means to ESPN. When you look at the revenue that ESPN is currently making right now from the ACC network, but just overall, when you look at this, they're going to have to pay. They're not going to get out scot-free. They're going to have to pay hundreds of millions of dollars, and we don't know what that amount is. But I mean, in your estimation, I mean, they're not going to get out free. They're going to have to pay hundreds of millions of dollars. Do you think? Correct?
Oh, I think it's going to be astronomical. I mean, one of the things about to recognize here is that, I mean, who's watching live TV anymore unless it's sports and or news? I think that the way that most, I mean, and this is from working with the number of people, content holders, through the years, advertisers, companies with advertisers, the way that you get your product or your advertising and marketing efforts before the consumer these days is not what it used to be. So live sports, things on your phone, which is incredibly, a great way to get to you. Through social media, through podcasts, but nobody's watching Days of Our Lives anymore, right? And nobody, everybody's now so sick of the cable subscription model that had the choice of a Soviet ballot, basically. Everybody's tired of that, and so the way so the value of these media rights are truly just going through the roof. And as I think I've mentioned before, there's a Wall Street Journal article a couple of weeks back about the NBA scoring a $76 billion deal.
Massive.
with NBC, TNT, and I'm sitting like, oh my God, who the hell watches the NBA? I mean, I mean, no offense, everybody, I mean, thank God Pittsburgh doesn't have an NBA team right now. Otherwise, y'all be blowing me up. But I don't watch the Hornets. I don't watch any of it, and so. If that's sort of the standard, and you have media rights, I think that the value is just astronomical. And so, considering that this was an intellectual property license that was indeed transferred, they signed this agreement, JJ.
Yeah.
And so when you sign the agreement, and then worse for Clemson and Florida State, when you take hundreds of millions of dollars under the deal, there are just simply, you got to be able to demonstrate a recognized contract defense, such as fraud, duress, misrepresentation, unconscionability, whatever it is, and they cannot do any of that. So all they can do is say, so that's one problem. The other problem is that there are equitable doctrines under the law, like waiver and estoppel, that when you sit back and you agree to something, we not only have your signature, but you also are able to demonstrate that they received hundreds of millions of dollars on the deal. Then you can't be in a law of equity. You just can't protest the deal. You can't then say that the contract's invalid. So what they're essentially doing is saying, well, there's a change in market conditions because we're making less money than the University of Florida or the University of South Carolina through their bigger deals with the SEC, or Nebraska's deal through the Big Ten. That's not a contract defense. Change in market conditions is just a change in market conditions, and it's not any kind of grounds to get out of a contract. I mean, I wish it were. I mean, I've made lots of bad deals in my life, and done some things I wish I could take back, but it's just not how contract law works.
Yeah, and again, you've done a phenomenal job on Twitter, X, whatever it's called now, and you've outlined that to where really the ACC's case, when you actually look at it from a non-biased perspective, it's extremely strong, and that leads me to the next question, to where you see these, and it's not even media pundits at this stage anymore. It's really the other YouTubers or potentially just the X accounts that really say, well, the ACC better settle or they're going to get nothing. So in your opinion, how just nonchalant is that? But more importantly, how crazy is that to where it's never going to happen? They're going to have to pay something, and the buyout's going to be massive. I mean, there's just no way that they're going to get nothing out of this, because the contract that they signed is what they knew. But more importantly, yes, they understand that the ACC is undervalued at this point. But to your point, you would agree, like you said, just because you're undervalued doesn't mean you can go back to the contract and try to renegotiate, correct? Because especially at this point.
Not after you've taken the money, and it's even more ridiculous when you're not offering to give the money back.
Yeah.
And that's essentially, what's going on. I mean, again, you have the equitable defenses that are problem. And by the way, I've written about this. There's such a thing called the statute of limitations. My God. I mean, I will tell you, this is a North Carolina contract. There's no doubt that this is going to be interpreted under North Carolina law. But in most states, the statute of limitations to contest a contract is 3 years. And so, I mean, my man, JJ, these contracts were signed in 2013 and again in 2016, and it's 2024. So there's that problem too. So, yeah, I mean, getting back to your principal question about possible settlement and monies, why would the ACC settle? I mean, as I've said, you don't fold with a royal flush. And you do have, as I've outlined, statute of limitation, equitable defenses, a signature on a signed contract. It just leads me to believe that there's very little incentive to settle. And, now I will say Clemson is taking a slightly different approach that maybe worthy of just a tad bit of explanation, is that they're basically saying, well, the grant of rights is a valid agreement, but the agreement with the ACC and ESPN agreement says conference for the purposes of a conference institution. I mean, it's a highly technical reading of the contract to which they're not even a party. So that would somehow in turn around and invalidate the grant of rights agreement. And that's a big problem, because, and I'm trying to give this in the most layperson way I can, not too over technical, but a court cannot just undo a contract absent fraud. Okay. In case of fraud, a court can just say, nope, that deal's, give the money back. I'm going to pull it back, whatever.
Yeah.
In the absence of fraud, the court is faced with a construction problem. And what a court can't do is add language to the contract so as to, it can do what's called the blue pencil rule, or the blue line rule, which is strike terms so as to effectuate the intent of the parties, which, I mean, you have tons of presidents coming on at the time all these things were saying, we want stability for the conference, blah, 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 blah. You can strike language, but you can't add language to it. And so Clemson's theory requires adding language to it, like definitional terms like conference institutions that are not actually in the grant of rights agreement. That's in the ACC ESPN agreement. So I think that stinks too. So Why would you settle? I mean, I think, and that leads to the question of, but well, what happens if Florida State just chooses not to perform under the contract? Well, then they don't get any money. So
It's that simple.
I mean, it's no different from somebody like Christian Wilkins is one of my favorite pro players. He played at Clemson, and he had an undervalued contract, and he didn't show up for work and for camp, and during that time he didn't get paid.
Yeah.
So it's just, and if he had stayed out, he wouldn't have gotten paid. So you know and if they were to take their media rights and go to another country, go to another conference, then the ACC still would maintain those media rights, and that probably requires a whole discussion that you're not asking. So anyway, I would say don't settle unless it really is commensurate with the actual damages going on, and I just think that that's hundreds of millions of dollars. I mean, it's pretty substantial.
And that kind of, to that point too, even with the grant of rights not settling, one of the things that really was touched upon yesterday in the national media was, again, you saw pundits that have no idea what's going on talk about how, oh, we're going to discovery. The grant of rights is now public. But and to
Right.
that extent, hasn't Florida State and Clemson and every other ACC institution had this for the past couple of years? They've had attorneys look at this contract from top to bottom for the last 2 years. So is that a major development, or is that a nothing burger from everything I can tell?
I think it's quite the nothing burger. Look, I've had the grant of rights agreement myself when I first started writing about this on LinkedIn back in 2020, I think 2021, something like that. And so the grant of rights agreement has been in their possession for quite some time. The ACC ESPN deal has been under lock and seal at the league offices in Charlotte, and that is, I understand, pretty standard. I don't think any team, whether you're in the SEC or Big Ten, in fact, I know this for a fact, none of those teams have easy access to the deals with the league and the media partner. So, but now that litigation has developed, they're, as part of the discovery process, fairness requires that they have access to the ACC ESPN deal. It just needed to be under a protective order. And that was the delay in Florida State's case, is that they refused to agree to a protective order, trying to say that every single thing is a public record. So it was entirely expected. I think it was a big nothing burger. I don't think it changes much at all.
And, again, just a couple more questions before we get into the prediction point, obviously, because I want to be valuable of your time. One of the things that was very brought up again recently was the potential of North Carolina entering a suit. We saw a lot of stuff with the Board of Regents and athletic directors. In your opinion, and again, maybe you can't touch on it or anything like that, do you think that North Carolina would enter a suit against the ACC just like Florida State and Clemson at this point? Or do you think that maybe they're starting to settle their boots into the terms of, what, hey, the ACC is our conference. We've been in this conference for years. We're ready to put our boots on the ground and stay here. Or is there a potential that they join that suit?
Well, there won't be joining anybody else's lawsuit. It would have to be their own lawsuit that it would file. Obviously, I have no idea what North Carolina is intending to do. I can tell you that their athletic director, Bubba Cunningham, has on a number of occasions come out and publicly supported the ACC. And has chided Florida State for even using the word barking. So it doesn't, and I don't know Mr. Cunningham other than through public reports, but I doubt that there is a single cell in his body that wants to have anything to do with the destruction of the ACC. But the more I think about it, I mean, it's a great question. The problem North Carolina would have is that doing anything, I mean, it's really interesting. The problem, if North Carolina were to try to leave without Duke or NC State and maybe even Wake Forest, I think that would be such a massive political issue in North Carolina that, already the Board of Governors has said, they've come out with some kind of rule or law that if you're going to change conference, you got to come through, the Board of Governors, and that's been widely reported to be a way to keep Carolina from leaving without NC State. So I would personally be, and then practically, so politically, it would be a huge problem for Carolina to leave without NC State. And then practically, how do you leave without a school that's literally 8 miles away in Duke? And, that that to me, I mean, if it comes to that, that's going to be the dumbest thing. I mean, I will lose all interest in college sports if it comes to that. So
Yeah.
and then I think Wake is an important player in this state too. So I I don't know what's going on in Carolina's mind. I would be shocked if it did file a lawsuit trying to get out. They got a really smart, able general counsel's office over there and outside attorneys. And I think that if they were going to file, they would have done it by now.
And it's kind of where my thoughts are, that they would have already done it by now. And look, we can't predict, 5 years, 10 years down the road. Who knows? Heck, I mean, every week it changes. I mean, we can't even guess what goes on in the next week. But
Right.
I'm with you on that in terms of, it makes sense that they stay in the ACC. But more importantly, one of the things that I think is very unique about North Carolina is the fact that all of the schools seem to be on the same page, whether it's NC State, Duke, North Carolina, Wake Forest, and heck, even the recent conversations that they've had about having to face other North Carolina teams like App State, ECU.
Oh, yeah.
I feel like it's like a circumference of just the universities have to stick together.
Yeah.
What did you make of that in terms of I guess not law. I mean, I guess not law, but maybe law.
It was a proposed law. It got out of committee. It just never got to the floor of the House. I thought that was. I mean, look, that stuff has been going on in North Carolina for probably 50 years, and where NC State's required to play ECU, and there's this effort. That effort was basically requiring NC State and UNC to routinely play Charlotte, App State, and ECU. And so, but it didn't. I don't think that's. I think it's highly unlikely that actually comes up. It seems like it's a 10-year issue before the legislature in Raleigh. So, highly doubt that.
Yeah, and I think just overall, I think the P4 universities are stuck in tight together. But yeah, if you had to face those teams every single year, I think it hurts with just out, your non-conference schedule and whatnot. I think there's just a lot of ins and out with that. With just the last couple questions, I think really the
Sure.
first one, when you look at a timetable, and again, a lot of this is perspective, guessing where we are. When do you think a timetable for this could even relatively be done? When do you think a decision on this overall, to where this just madness and this circus overall just comes to a fold and we get some type of decision?
Well, obviously, I wish I had a crystal ball, and I could make that. I mean, so since we have all these things going on in separate jurisdictions, it could be years. I tend to think that it's going to be faster than that. I think, again, as I said earlier, this is a pretty important matter to the state of North Carolina. I think we're something like the 6th largest state now.
Yeah.
Which is unbelievable to me. And deep business interests at stake. So it's entirely possible that the North Carolina Supreme Court moves quickly. And then, JJ, I am telling you, these cases have early summary judgment written all over them. Okay, where for your viewers, a motion for summary judgment is something that basically ends the case early on, because we say that there's no real questions of fact and there's only questions of law. And this case really is teeming with that. How much discovery do you need, JJ? I mean, if I were litigating this case, the first person I would call is Eric Barron, or two people, Eric Barron, John Thrasher, on behalf of Florida State University. Say, is that your signature? Yes. And did you receive money under this agreement? Yes. Pretty much end of story at that point. And so, you can, it's not a next question. So, and I get there's all the value of other media deals or whatever, but they're just not relevant to the ultimate question under pure contract analysis. And And by the way, this happens all the time. I mean, people assign intellectual property rights for a period of time all the time. And things about it just, the term of it is too long. Well, I think it's incredibly important to realize that under the Copyright Act, that an author can take back their own copyright after assignment in the event of market corrections or market explosions or something like that. But that's after 35 years. So it's interesting because we're not even close to that. So presumptively, the grant of rights agreement, just being 35 years, is not that. Well, it's not 35 years. It's what, 12 more years. It's
Yeah.
just, but it's in its total 20 years or something. Presumptively, it's not adhesive to the point that it's unconscionable or anything like that. So anyway, I think that some of those questions can be resolved pretty quickly in that you'll get a summary judgment motion and the court can resolve this case and get it to judgment. And then the question becomes, well, you're gonna have multiple appeals, and I get all that, but I just tend to think that given the amount of money at stake, the courts are likely to move quickly.
Mm-hmm. And I think just to wrap it up, in your opinion, who wins this case, or is there ever even a winner at all in this type of a case to where there's so much litigation going on? Is there a winner defined, whether it's the ACC, Florida State, Clemson? In your opinion, what do you think that road looks like, down the road into the end of this year or next year? Who do you think really wins this case?
I think the ACC has an incredibly strong case, and the ACC wins this case, hands down.
I
Now,
agree.
whether there's another resolution that happens where they split football off into its own thing and separate, that's another question. But this is just black letter law. I mean, I know that we're all sports fans and we're all like pulling for our teams. And I get the frustration that's coming out of Tallahassee and Clemson with the disparities in the amount of money at play. I get it, but it's just black letter law. Nobody's really trying to, and so we can resolve it at an early summary judgment motion. And so it's just, the law's the law. I wish I could change it to make it easier on people. I wish I never bought the Peloton stock because I thought it had a great app and a fantastic, product. Man, that was a mistake. Can I come back and just, get my money back? I mean, bad deals happen all the time. They're part of life. The law is deeply on the ACC's favor. And I wonder if it was just like John Q. Public bringing this case, if it wouldn't be immediately laughed out of court and sanctionable. I mean, honestly, because I'm not trying to raise the stakes under this, but they signed the agreement. They took the money. They didn't protest for at least a decade. Case done.
Yeah. Well, I can tell you this. Beyond thankful for you to come on. Again, 45 minutes here. I want to be respectful of your time, but more importantly, just the amount of knowledge that you were able to just involve here. I cannot thank you enough. For the viewers here, obviously, again, as always, reach out to David. Obviously, his X account, McKenzie Law, at McKenzie Law on Twitter. An incredible follow. I can tell you this is the first time he's on the show. This will not be the last time. And again, I know this for a fact, guys. You got a lot of facts, but more importantly, the truth, the non-biased truth here. Again, David, I can't thank you enough for coming on, and I know your schedule is so busy, and I just can't thank you enough for just really presenting facts and just knowledgeable information here today for the viewers. And excited to get you back on again.
Happy to do it. Thanks for having me, JJ.
Guys, as always, if you have not done so, subscribe to Talking College Football with JJ Kitchen. And of course, always hit the subscribe button, but hit the like button as well. If you have questions for David, obviously go on to X, ask questions there. But more importantly, even drop the comments below. I love to read the comments and to hear everybody else's thoughts on what was potentially missed. What do you want to know when we get David back on, when his schedule's not busy, getting him back on to ask him more questions. But as always, guys, again, thank you for tuning in to another episode of Talking College Football with JJ Kitchen. As course, and always and forever, hail to Pitt, but also, let's go ACC. I'll see you guys next time.